member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, New Jersey. Today's tip, and before I go into the tip, just so you understand, the purpose of my daily tip is to give you just a very small piece of information to help guide you through some of the New Jersey family law and divorce issues. I do much longer videos, and actually this week I intend to do a how-to video on custody so you get a much broader picture. But for today's purposes, I'm here just to discuss the basic hearings you can expect to have inside of a custody case. Essentially, you're going to have three separate, not necessarily hearings, but three separate parts to a custody case. Assuming first that you're in court on a custody matter, would have brought you there either by a motion, a formal application, or papers that one of you filed, one of the parents filed. The first thing you're going to have is court-ordered mediation. Mediation is a court-sponsored program. It's confidential. Normally, attorneys do not appear during it, but they're certainly available if you have one for questions. But in my experience, I've never attended any custody mediation. It's sponsored by the court, so there's no cost to it, and it's confidential. So whether or not you come to an agreement doesn't get to the judge's attention, and nobody knows anything that was offered or rejected. The second phase of a custody case is going to be where the court or the parties agree to engage some kind of expert witness. It may be a mental health expert. It may be by agreement. Both parties or both parents may agree to a certain professional or expert witness. And some courts have certain organizations or individuals that they actually will send you to for the evaluation. It's generally called a best interest analysis, but some counties call it different terms, so I would just go by the phrase of best interest. And the purpose of that evaluation is to gather the facts for the court to help guide the court or the judge in making his or her decision. Then the last stage is obviously going to be a trial. If your matter doesn't conclude through the mediation, once you have your expert report or your best interest report, you would hopefully get a trial date scheduled. Now, this is a very small snapshot of the custody process because all cases, especially custody cases, will have several different components to it and a lot of other hearings. The three that I'm mentioning today are just your basic points the court will put you through to get to a custody determination. But you will often have additional case management conferences, you might have some discovery, could be motion practice. So none of that is inside of the scope of this tip. This is just to give you the basics. But like I said, I will be doing a how-to video probably on Wednesday. I'm going to do it live just like I do these, where I go much more in depth into the custody process for you. But if you like this video or any others, do me a favor, give me a like and share it so that more people get to see it and it gets circulated a lot better. With that, I thank you, and I will see you hopefully on Wednesday.